We move on to the Indian position. How is the Indian law with regard to water? Let us quickly look to the fundamental of the land. What does the Indian Constitution provide for as far as water is concerned? Do we have a fundamental right to water? Actually, if you study the Constitution and go deep into it, there is no direct reference to any fundamental right to water. All that has happened is the higher judiciary in India has ruled it as an aspect of fundamental right to life. So, I and you having a fundamental right to life under the Constitution has an urgent effect. For my quality of life, I need water to survive, sustain, and flourish. And for that, we have a fundamental right to water as a derivative right of right to life. So, no direct right to water. I have given reference to a couple of cases. I would very much urge the students to study this. There is one case, one of the earliest cases from Kerala, the case of Atakoya Tangal versus Union of India, and another one, the MC Mehta versus Union of India case, which deals with Bhatkal and Surajkund lakes. Then there are quite a few other cases also I have mentioned here. The point that you would notice from this is that the Constitution does not assure me and you any kind of a fundamental right to water, but it's only through court's intervention some kind of ancillary right to life. This right to water is being considered, but not actualized, not even articulated in any policy or a law in India till date. One of the specific feature of this is, as the courts have intervened, they have made it very clear that if I have a water body on my piece of land, if I have a well on my piece of land, I have a complete right over that. No authority of the state through an administrative order can either prevent, restrict, or limit use of the water that is there on my property. And for that, you must have an act of the state. A legislature should come, and that only can restrict and regulate my right. Then, if I do not have a positive right to a fundamental right to water, is there a negative obligation on the part of the others, like the state? Is there an obligation on the state not to subject any citizen on grounds only of religion, race, caste, sex, or place of birth to any disability, liability, restriction, or condition with regard to use of wells, tanks, bathing ghats, maintained wholly or partly out of state funds, or it's a state property, or which is meant for general public? The answer is yes. All these are available to everyone. There shall not be any discrimination. So that kind of access to a public resource and water which is in the public domain is available for all without any single exception on these grounds. That's the only saving grace that you have. Then, how is water managed, which is there in the public domain? We already know water that is there in my private property is mine, state cannot intervene. But what about water that is managed in the public domain? Who does that? How it is being done? Well, this is being done under the constitutional scheme by the division of power between the center and the states. The central government and the state government alone can make law on water. But even in making law on water, for making and enforcing laws concerning water, which is very much within the territory of a single state, it is primarily vested in the states only. You have entries under the Constitution, as you could see on the slide. the scope for the center or the parliament to make a law concerning water is only confined to two areas. In case of interstate rivers, where there is a dispute, then in relation to that, to resolve the disputes, a law can be made by the center, or a shared river amongst two or more states in regulating activities in relation to the river valleys, the center can make a law. So, the sum and substance of it is any interstate water body or riverine system comes within the purview of the center to make a law. Any water body or river within a particular state is the exclusive lookout of that particular state to make a law. One shall not be transgressed upon by the other in making a law, creating institutions of enforcement, and putting it into application. So, where does the local self government exist in the whole scheme of things? We know very well, under the constitutional system, we have the center, the state, and the local government as the three layers of governments. We know that center and states can make law. We also know that the local self-governments cannot make a law. But what is their status? The status is the state legislature, after having made the law, it may empower the local self-government institutions like panchayat, municipalities, and municipal corporations to administer and implement laws concerning the management of local resources. And what are these local resources? Minor irrigation, fisheries, water management, watershed development, drinking water, maintenance of community assets, etc., all relating to water, can be administered by the local government if the state government gives them that power. That means state government has all the power. It has to transfer that. After the 73rd and 74th amendments to the Constitution, it becomes the duty and responsibility of the state government to transfer the administrative power with regard to these local resources and subjects, as I've just mentioned, to the local self-government institutions. So, as and when they transfer, these subjects are going to be handled only for administration locally by the local self-government institutions. That's about lawmaking and enforcement in general. Let us get very specific to water. And as you know, is there any clear policy as the driver, as the pole star, as the guide, as the steering wheel to advise the lawmaker as to in which direction the laws to be made and enforced? What is the basic tenets of governance? And that comes through policies. We know that state is the one which makes laws concerning water generally, and since water is by and large a state subject, ever since our independence, I think for well over 4 decades, the center did not venture into this field of policy making concerning water. Even making a law concerning water, the center did not get into. Because as you know that there will be a clash between the center and the state. The states would argue that, look, this is an exclusive area in which we could legislate upon. You are unnecessarily interfering. The center-state relations would get eroded. Please allow our autonomy, our independence, our ability to make a law and enforce it for ourselves. Why should you interfere? So, in order to not to get into any kind of a clash with the states, the center tactically refrained itself from either coming up with a policy or a law. But you know, the center over a period of time realized that there are certain problems, although with regard to water within a particular state, which is very much within the territorial jurisdiction of a particular state, the kind of problems that are there in relation to that water may spill into the neighboring states, either on an environmental count or on account of the use of resources and the depletion of that and the detrimental effect on the neighboring lands which is there in the neighboring state, or for whatever reason, the center thought that it is better, instead of interference, we will come up with some draft policy documents, more for guidance, as models for the states to draw inspiration from, emulate, and translate it into application at their various levels. So it's more like an elder brother giving an advice to the younger one. And in 1987, the Government of India circulated its first draft national water policy. And later it became a little bold. From a draft, they came up with, well, draft, draft is something which is later to be transformed into the policy. But draft remained a draft for 15 long years. But by the year 2002, the central government got a little bit more confidence. There are so many things, so many issues over which the states will have to come to us for guidance, support, resource support, technical support, or anything like that. And we will use that. And to use that, we will try to tell the states that, look, we have come up with a policy. It's useful to you. And if you are going to adopt this, you will have central funds coming your way. And no state would refuse when central assistance would come their way to actualize and implement what the center prescribes to them. So, by the year 2002, the center realized its power. And it, although under the constitution only the states would make it, the center started foraying into the state subject and came up with a clear policy pronouncement on water in the year 2002, which is actually a little bit of an elaboration and expansion of the draft policy document of 1987. It revised it in the year 2012, and the major reason as to why the center got into it is of the increasing dependence on the part of the states for central assistance on various issues. There are international arrangements in which the national government is a party, and if those international arrangements are internalized within India, then technical and financial support would come our way, and the center may share the same with the states. There are mega projects to be organized and conducted for which a lot of resources required, and the states by themselves will not be able to raise those resources, and so they look up to the center for assistance. And so the center started coming up with its own policy. Look, this is our water policy, you adopt it, then we will support you. That kind of a thing. It's almost like a give and take. This is our prescription, you adhere to that, this is our assistance. Then the 2002 policy got revised in 2012, and there are a number of reasons as to why this change came about, why the policy document was revised. And for that, a number of reasons exist, and one is the center taking greater interest in making policy and law on water because, as I did mention, mega water development projects started getting international assistance, and center had a lot of funds to make available to help aid, support, and handhold the states. And so the increasing demand for the central intervention became very necessary. And by 2012, the government of India started thinking big about, as a nation transitioning into from a developing country to a developed country, And with economy improving, the need to make investment in major developmental activities, and one such was about linking of rivers. Why linking of rivers? Well, the demand was that there are some states which have plenty of water in them, so many rivers pass through them, perennial rivers, and there are states which are parched, who either have rivers but seasonal rivers. And so, if you link rivers across the nation, it's quite possible that there would be water availability for all at all times. A great idea. The idea of interbasin transfers to deal with water drought and deluge situations in different parts of India did lead to a further recasting and reworking of the policy document. I place before you a key feature of the national water policy that was evolved in the year 2012. And this I will contrast it with the 1987 draft policy document and the 2002 policy document in a limited way, primarily highlighting what actually emerged in 2012, and incidentally I may make a mention of what actually were the priorities in 1987 and 2002 incidentally. The key features of the National Water Policy 2012. The first and the foremost feature is to envision an integrated water resource management, IWRM. What does it mean? It actually takes river basin or the sub-basin as a unit of planning, development, and management of water resource. It's a process that promotes the coordinated development and a management of water, land, and related resources to maximize the resultant economic and social welfare in an equitable manner without compromising on sustainability of vital ecosystems. In short, it's a holistic approach, not to consider a bit of a water stream running through a particular area within a state, but to consider the entire ecosystem as a whole and to think of a coordinated development of the entire aspect of management of water, land, and related resources so that economically and socially and in an equitable way, the entire development of the area, the people, and the resource would happen. The ecosystem would be conserved, the well-being of the people taken care of, because you're looking into the pros and cons of different kinds of uses and application of each of these resources in an integrated way. IWRM. The second feature is an insistence that it is very desirable that while you have different uses of water, especially in the case of a river, you can use the riverine water for a number of purposes, but make sure that when you are thinking of a river, it's a living entity and it should remain alive. And for that purpose, you need to ensure that there is a minimum flow. It's also called as environmental flow in rivers should be ensured. That means you have to maintain the minimum flow of a portion of the river to meet the ecological needs. Don't drain it completely. If you drain it completely, it is not just river. It is not just water. Water that is there in the river is related to the entire ecosystem, that it feeds into so many life and life forms that are dependent on it. And if you drain it, those life and life forms which are dependent on it, which have enriched the neighboring ecosystem, would be lost. And to that extent, the quality of life would get affected, and the ultimate resulting consequence is that the water drain, once it completely drains, the river resuming its old status of recharging the aquifers on the either side of the riverine system would be to that extent lost. And so you may have many dead rivers if you completely drain it, maintain a minimum flow. The third one, interbasin transfers. To meet basic human needs and achieve equity and social justice, interbasin transfers of water need to be considered on the basis of merit of each case after evaluating the environmental, economic, and social impact of such transfers. As I did mention to you earlier, the idea comes from this, that there are some states which are water surplus states and some states which are water scarce states. And so, if water has to flow from one state to another, it is not just water flowing from one state to another, but there are so many other attendant aspects that need to be considered. What are the environmental impacts of such a flow? What are the kind of economic impacts? What kind of social impacts it would take place? And on balance, if you find that all these are not going to be affected adversely, then you may go ahead with interbasin transfers. Because the idea may be good, but in terms of operationalization, if it leads to destruction, if it leads to something which is undesirable, then it is not proper to proceed further with that. So, use the data that's available, use all the scientific knowledge that are available on that, and then do an assessment of that. And on balance, if you find that it is beneficial, then you may go ahead when you think of interbasin transfers. A lot of expenses are involved in it. Whether these expenses are worth it, you need have to look to. A lot of impact would be there on the environment. Is it something that is manageable, repairable, recoverable? Look to that. The claims and entitlements of the people in the upstream to that extent may get reduced. Will it affect their quality of life? Consider that, based upon which you take a call. Then the other important feature of this policy document is with regard to the groundwater management. The concern is about declining groundwater levels in overexploited areas. The urgent need is to arrest the trend. And how do you arrest that? By introduction of improved technologies of water use, incentivize efficient use, and encourage community-based management of aquifers. If you bring in more people to share both rights and responsibilities, there will be a lot of rational, just, proper, equitous, and better utilization of water in an optimum way, and to that extent more exploitation may be contained and controlled. Groundwater is something which cannot be replenished easily because it goes through a particular natural cycle, and refilling, reclaiming, and recharging is a very tough task. It takes over a long period of time. Hundreds of years it would take. In fact, many of the waters that we are digging wells into and drawing it from them are actually something that has been stored sometime around 1300 AD, 700 years back, as you go deeper into it. And so, this is something which is a very rich resource which can be used only in adverse time and not to be spent like someone who has excess of it. There is no excess water available. Manage it very, very carefully. Groundwater management requires a far more scientific, technological application and use, and that is something that is stressed. The other interesting feature is for the first time there is a paradigm shift from 2012 onwards that water in its normal form is not something that can be used. It requires a lot of treatment to be given to that, and for which some kind of expenditure is to be incurred. And the one who is rendering that service of cleaning up and making it available, you have to pay for the service cost. And water is not something, since it is not freely available or easily available, it is an economic good. The complete change in the approach. The earlier approach was water is natural, a national asset, is something that should be shared with everyone, is now pricing of water for the services that somebody does for you, to make it available for you, to make it available for you in a better shape and form than what it was, in a usable form, for which these services don't come free. You need have to pay it, and pay for it as water is an economic good. The idea is to really encourage people to make efficient use of water, not to consider it as a free for all, to conserve water. If you say that it is priced, people will think twice before spending money. So it promotes conservation, it helps efficient use, and this paradigm shift is essentially to help and enable the service provider to get incentivized and to facilitate better service. And in a way, the private entities who had the expertise and ability to deliver those kinds of services were also encouraged to make investments in this field. The urgent need for managing floods. Every effort be directed towards averting water-related disasters like floods and droughts through structural and non-structural measures, and preparedness for flood or drought with coping mechanisms as an option, and on rehabilitation of natural drainage system should be an integral part of such efforts. So precaution, preparation and action without wasting time is one of the excellent means whereby you could manage floods, and for that a policy document clearly elucidates the methods and manners of dealing with floods. Water use efficiency. The project and the basin water use efficiencies require improvement through continuous water balance and water accounting studies. How do you ensure efficiency of water use? We have many projects with regard to water management. We have basin management of water. But the key to that is efficient use of it. And for that, you need to ensure certain level of water be available all the time, and you should account for the use of water for different purposes, how much you have used, why you have used, whether it was necessary, a kind of accounting and auditing. And for that, you need information, you need collating information, you need consolidation of information, you need dissemination of information, and working it and come up with mechanisms of putting those information to use. And for that, an institutional arrangement at the national level was contemplated to be established for promotion, regulation, and evolving mechanisms for efficient use of water or basin or at the sub-basin level. As you could see, very ideal things are put forth. Most of these appear like home truths, commonsensical, but something that you do see in scarcity is that common sense of use of water. And since this is rooted in common sense, it may appeal to everyone. That is the thinking on the part of the policymaker. And you know very well that policy is not law, but policy actually gives the direction in which the governance needed to be steered. And for that purpose, policy is important, and for which you make laws and you enforce and you guide the administration. And this policy, in the last 7 years of its working, has come under review now. Why should it be reviewed? It is just 8 years back you made it. Well, there are so many developments. The policy needed to be dynamic to absorb and accommodate these developments. And what are they? They're the challenges of climate change, which we did not experience earlier. And increasingly, the state is withdrawing from making investment in this public sector because it needs huge investments. And state does not have that much of money, that much of resources. And here are private parties who get attracted to make investment in water because now investment in water is also going to be a paying proposition, because for the services you render, you get paid. You know, as a fact, globally, water business is perhaps the second most flourishing trade in the world. Second most flourishing trade in the world is water business. Which is the first one? Of course, arms and ammunitions are the first trade. Very lucrative. And water trade is the next one. And so naturally, where there is money and where there is a demand, there will be a business. And so the businessmen would be interested in making an investment in it because they can get good returns. But till now, it has been primarily a state-managed, state-administered, state-regulated, and state-facilitated process. Private engagement has been kept to a minimum. And now the state is finding that there are takers. There are those who would bring in fresh ideas, newer, better technologies, have monies available with them, have resources to invest, and so to facilitate that, we need to rework our policies. That's another reason. Climate change is one problem. The need for accommodating private investment in terms of resources and expertise in management, and bringing in changes in the regulatory mechanism. And regulatory mechanism that we have is violations, punishment, that kind of thing. That won't do anymore. What you need to do is have a big bandwidth of facilitation, incentivizing good deeds, incentivizing services rendered, and then if there are clear violations which are unmanageable, which are objectionable, which are something which is going to be detrimental, punish them. So in a graded way you are going about water resource management, and this requires a new kind of a regulatory frame, and for that policy changes are required. Revitalization of rivers. India is supposed to have 15 major rivers of the world. If there are 100 major rivers in the world, 15 of them are in India, and these 15 rivers in India, without a single exception, international statistics convey to us, are the most grubbiest rivers in the world. And the moment water is polluted in a riverine system, the river gets choked, river dies. Need for revitalization of rivers is the need of the day, and there is a need for setting up of a national bureau of water use and efficiency, and for all that we need to really think afresh about a water policy. So the emphasis would be on hydrological boundaries rather than administrative or political boundaries of states. So we will consider water as of national importance, and so the center need have to be the guide, need have to really show the way in all these aspects which have freshly emerged, and then help the states to evolve their own policies and governance structures in effectuating and effectively implementing them. It is in review, and it is still on the anvil. That's about policy. These are ideals, these are directions, but the real action commences only when you have a law, when you have an enforcement mechanism to put that into application. What is the legal regime that we have? Statutory law. If you just take a panoramic view of the entire legal landscape concerning water or legal waterscape, it is characterized by the coexistence of different principles drawn from the common law traditions of the colonial period. As I did mention, the owner of the land owns everything in relation to water. That's one principle. And then the common thing that we have, and the most prominent that we have, is the irrigation law. Irrigation law prevalent all over India, in all the states, and these were actually initiated during the colonial period when the Britishers were ruling us. And in addition to that, some of the judicial pronouncements in relation to water. I did mention about water rights, human right to water. All this actually shape, craft, and work the law in relation to water. We know that states have exclusive power to regulate water supplies, irrigation, canals, drainage, embankments, water storage, hydropower, and fisheries. And so obviously there is no umbrella legislation on all this at the national level. Quite understandable, because that is the separation of powers, division of powers between the states and the center. And we also know, with the knowledge that we have of the Constitution, the center exercises its lawmaking power only on the following issues: territorial waters under the law of the sea. There is a law called as the Territorial Waters, Continental Shelf, Exclusive Economic Zone and Other Maritime Zones Act, made in the year 1976 and amended from time to time. This is a central law because this is an international aspect to it. And that which is not within the confines of a single state, it is for the national government. And that's how the national government comes into the picture. Then the second one is rivers and water bodies which are interstate in nature. So interstate rivers use and interstate water disputes. And it's only there you have the central law coming into existence. And the only other circumstance when the center gets into the picture of making a law on a state subject is only a good number of states come together, make a combined plea to the center to make a law to be enforced at the state level. It has happened earlier. In the law concerning pollution control, we have already seen that. There is that Water Prevention and Control of Pollution Act. This was a central law, although it is a state subject, for the obvious reason that the center made this law because more than half of the states in India made a submission to the center: please make a uniform law for all of us, and the center will oblige. And this we have already discussed, so I don't need to go back to the details of that. Now, I did say that when there are disputes with regard to sharing of waters and management of shared waters between the states, there is Interstate Water Disputes Act made by the Government of India in the year 1956. So this is to settle dispute among states. What does it do? It establishes a tribunal to adjudicate upon disputes that have remained unresolved, even with any number of negotiations between the states. Very interestingly, as you may notice, the tribunal, look at the status of the tribunal. Whatever decision it gives, it is final and binding. There is no scope for an appeal. From the decision of the tribunal, even the Supreme Court has no jurisdiction. This is written in the Constitution, and so for interstate water disputes, the tribunal has the final word. There is no appeal. This law is in application. It has been applied in a number of interstate disputes. We have Kaveri, Krishna disputes. But as a matter of fact, the results are very mixed. Mainly because of the fact that the conflicts are long drawn out and the procedures that are developed for the tribunal to function and adjudicate upon are very loosely crafted. And when the law is loosely crafted, there is a scope for any number of interpretations, and there is a scope for many escape routes of delaying things. And that's precisely is affecting the Interstate Water Disputes Act to deliver what it promises. The other one is the River Boards Act of 1956. It provides for the establishment of river boards for regulation and development of river valleys and the rivers themselves. This has hardly been put into application. Then, if you just go back in history, what you do see is that there was a River Conservancy Act made in the year 1884 by the British. It stipulated regulation for the development of floodplains. Look at the visionary thinking. Floodplains, how they have to be regulated and developed. There is a template available in the 1884 law. And this was in application in Tamil Nadu and Andhra Pradesh states. What did it do? It prohibited any construction or plantations within the riverbed. After our independence, this has not been put into much use or application. In the year 1975, the Central Water Commission, the central ministry, on behalf of that ministry, it had circulated a model bill for floodplain zoning on the same lines of the River Conservancy Act of 1884. Unfortunately, the states have not positively responded to this initiative of the central government. You know the reason? The reason is obvious. Each and every state wants to develop wherever it is possible, wherever there are public lands. And on those plains which are inundated during the rainy season, when floods occur, the rest of the year it is dry. And it is in these areas so many activities have come. Allowed, licenses given, encouraged to set up plants. Just forget about plantations. Even industries have come in floodplains. Housing societies have sprung up. All these have happened because the state governments have allowed that. And the usual arguments that they come up with is that there is increasing population, there is an increasing demand for housing, there is an increasing demand for development, there is an increasing demand for employment. We have to look for those areas that are available, and these are the areas available. And you know what happens? During the rainy season, as we are experiencing year after year, the havoc caused by floods, the loss of life, limb and property being huge, irreparable. It's happening every year, mainly because of the states not acting well in advance. There is already a template available. The center is still trying to negotiate with the states. Sometime in 1975 it came up with, these are not happening, and unless there is a consensus among states and an agreement to the center to come up with such a kind of a law, this will never see the light of the day. We had a lesson. Devastating floods in Uttarakhand in 2013, Kashmir and Pune in 2014, and very closer to Bengaluru in Kodagu. The devastation was of such dimension in Kodagu and Kerala. So much of havoc was caused a couple of years back. These were the triggers for the Ministry of Environment, Forest and Climate Change to come up with a draft notification on river regulation zone notification under the Environment Protection Act in the year 2016. So it came up with a draft as to how to manage these floods, and for that a river regulation zone was attempted to be proposed. The idea is to regulate river regulation zone, as you could see here under this act. It is to regulate industrial activities on the banks of river stretches having floodplains. Once again, the required positive response from the states is not forthcoming. It has been 4 years since this draft is in circulation by the center. The states have not positively responded to that. The center is still optimistic. I think as late as last year in the parliament, the concerned ministry had conveyed that a large number of states have shown some interest, but still negotiations are going on with the other states as well. Until consensus is obtained, we cannot come up with any law pan-India application. Then there is another bill that is in circulation, National River Ganga Rejuvenation, Conservation and Management Bill 2018. Yet another effort of the center in protecting, conserving and in sustainably managing interstate rivers and other major rivers in India. This is a fairly recent one, as late as 2018. It actually comes up with a set of do's and don'ts of human activities, a beautiful template. It bans any detrimental activity that would affect the integrity of the river. Sand mining, prohibition of that. It lists out a number of activities as unauthorized and imposes stiff penalty for violations. Well, like all those previous good exercises, the responses from the states is still awaited. There is another bill in circulation, the Groundwater Sustainable Management Bill of 2017. It is issued by the Ministry of Water Resources, an excellent template for states to adopt to address the growing groundwater crisis, and it follows the earlier model bill which the center itself drafted way back in the year 1970 and updated several times over till the year 2005, and now you have the latest version of it. If I can elaborate a little bit, because this is something which would be very useful for the states, it proposes a different regulatory framework from the century-old, outdated, inequitable and environmentally unsustainable and unfriendly legal regime. What was the position earlier? Private owner, private property, groundwater, state subject, so exclusively private or state. Never the center would get in. With the result that it used to be a situation where somebody who had riches of water did not have an obligation to share it with others, and even within a state, if it is a communitarian property, communities were not made part of it, and the state's management was much left to be desired. Now you have a clear recognition that water is an undivisible whole, a recognition of the unitary nature of water, the need for a decentralized control over groundwater, and the necessity to protect it at aquifer level, recognizing water as a public trust and groundwater as a common pool resources, and exercise of precaution in accessing, using, managing, allocating and sharing such a water, and also taking care of the developmental activities in its neighborhood as not to reduce, limit, or eliminate the availability of groundwater resources is something which was absent in the current water law regime is being put forth at the center stage under this new bill. Actually, part of these ideas are already incorporated in the laws that have been enacted from time to time in the last 10-15 years by a number of states. But not all these ideas. And this is in circulation now, and there may be changes in these laws by the states, taking the cue from the central bill, which is actually the intent of the central bill to act as a model bill for the states to emulate. Luckily, most of the states are trying to at least borrow a few of these ideas and effecting changes in their respective laws to align with this model bill. Then finally, irrigation law constitutes historically the most developed part of the water law. The Northern Indian Canal and Drainage Act of 1973, actually it is 1873, for instance, because this was done during the British time, so it is the 1873 law. It regulated irrigation, navigation and drainage in North India. As a state subject now, each state has the power to use and control for public purposes the waters of all rivers and streams flowing in natural channels within its jurisdiction, and as you know, that irrigation law is under the exclusive lawmaking power of the states, and they have made the law accordingly. And these are the only laws that are in vogue and in application in every state. There is an irrigation department, major irrigation and minor irrigation departments, ministries and departments are created in relation to that, and they are the ones who by and large are regulating all activities in relation to water in each and every state. That's primarily the legal regime concerning water. But the discourse on water will never ever be complete without at least some passing mention of two other very significant aspects in the entire system and scheme of water management, which is actually outside the law, but which should inspire policy and lawmaking, which should actually guide, help, and enable and empower the water law regime and enrich its content. And what are they? Number one is something which the courts of law have done. And number two, something which has been there with the communities of people. Let me start with the first one. Very quickly refer to that. Right to the river. It is recognized for the first time by the Uttarakhand High Court. Rajiv Sharma and Alok Singh, their lordships, in that High Court, they declared Ganga and Yamuna rivers and their tributaries as legal and living entities having the status of a legal person with all corresponding rights, duties, and liabilities. They even appointed 3 officials directing the state government for making such an appointment, who would act as legal custodians responsible for conserving and protecting them, and ordered for the establishment of a management board within 3 months' time. Unfortunately, the decision that came a couple of years back has been challenged. You know why? If you give that status, then a lot of claims would be made if water body or the water stream like the river Ganga and Yamuna as human beings becomes a legal entity, they will be subject to rights and duties. So flooding would actually make them liable for the loss of life and property, And if they become liable as the guardians, the state government would become liable. And huge expenses will have to be incurred by the state, and the state cannot manage that. And so the states have gone in appeal over this decision, and the Supreme Court has given a stay, to the decision and its implementation, and it is still not lifted. Anyway, the idea of a river having a right, a new concept in Indian sense, which was not there earlier. Actually, this is borrowed from what happened in New Zealand a few years back, where a particular river was given a legal status. Borrowing from that, here also the same idea has been put forth. How far it is going to be made applicable, time only can tell, because the final position has not been articulated as it, but a new idea has come into existence. The second one is a bit of a reflection about the water traditions of India. This is something in common, something that I think every one of us know, or if any of us do not know, we should know. For the simple reason that India has a very rich tradition of conservation of water, with the elements of ownership and responsibility vested in communities of people. And if you look into the position of women as conservators, we have instances, and we have folklore, we have historical records, we have documentary evidences to show large water bodies built by women. And these water bodies, they include step wells, tanks, and even ponds. There is a water heritage site called Queen Step Well, Rani Ki Vav, in a place called Patan in Gujarat. And there is also another place where there is Rani and Padam Sagar in Jodhpur, built by queens. And we have umpteen number of examples of Devadasis building water bodies and a tank for the benefit of the public in Yagati, Hosakote, Nagamangala, and a number of places in the state of Karnataka. Conserving water and knowing the importance of water and making it available for others is part of the tradition of communities of people, and women have been in the forefront is an illustrative example. The other example is with regard to water traditions of conservation and its maintenance. There has been pre-monsoon ritual in Rajasthan. I am quite sure such rituals have been there either immediately after harvesting or before the onset of monsoons in all the other states in India. But I am just giving you an example of pre-monsoon ritual in Rajasthan. It's called as Lasipa, in which the entire village gathers, cleans, mends, and desilts all water bodies. By the same token, during the fertility festivals of Gangaur and Akhatij, women come together in northern India to clean lakes and tanks. A tradition, a time-tested and a time-honored tradition, teaching us the basic ethics of conservation and maintenance of water bodies. There is this agricultural system of Apatani tribal groups in the Arunachal Pradesh. There is a valley in Arunachal Pradesh called Zero Valley. Zero Valley. Z-I-R-O. It's a plateau. Here, the water plains irrigate the paddy fields in the entire valley through a network of irrigation canals and channels done by these people. The women are the ones who usually manage these fields. The water used in the paddy field flows to more fields in the valley downstream. Keep in mind that this river is a very small river. Water availability is very limited, and the system they have worked out is such that the water is recycled. That means once used, it becomes polluted, and a process worked out in a network of irrigation canals and channels of purifying them and reusing them. And the water used in the paddy field flows to more fields in the valley downstream. These merge back to small streams, which flows back to the river at the last. So look at the water cycle here. In this way, there is a perennial source of water in the valley, adopted, adhered to, practiced since time immemorial by this tribal community. They have imposed very strict regulations, and one of those regulations is not to construct modern structures in the vicinity of these paddy fields, as they would disrupt the ecosystem. Now we are talking about command area and area where water gets collected and then flows into a valley, into a riverine stream, and how these needed to be conserved and protected. The tribals have been practicing it since time immemorial. These traditional wisdoms need have to be mainstreamed and be made part of our policy and law. And for that reason, I have placed this before you. There is a community in India, a group of people who have been engaged, and they are called as Niruganti in the state of Karnataka. This is the gentleman who traditionally controlled and managed and distributed water in irrigation, for cultivation, and for all such activities. And this is the one who was the regulator, manager, controller, and the one who would decide on allocation. A traditional practice, not a government official. To put it in a nutshell, if you look at water law and governance in India, it presents a contrast of colonial approach of state control and management on one side, and wonderful traditional, highly idealistic practices of communitarian ownership and management. Two contrasts. And the two have operated on parallel tracks. Even when they are operating on parallel tracks, there is an overwhelming domineering influence of the state control and management, so much so that this has actually relegated the traditional practices of communitarian ownership and management to the background, to the margins, and they are on the verge of extinction. It's time that these are to be mainstream, and the idea is essentially to highlight these major features for your consideration and study. That completes and concludes our examination and analysis of water law, policy, and governance, international and domestic perspectives.